there was a debate as to whether
Yeah,
Mr. Ramusipili can use photos
yeah,
that were obtained pursuant to an investigation in the second docket, First Lawyers Cast 3751 of 2019.
yeah.
We raised an objection. We subsequently had a conference with the defense regarding those photos, and Mr. Ramusipili has indicated that he will no longer be using those photos, subject to confirmation by him. However, my lord, we just want to sound a warning to my colleagues regarding the use of statements either in this docket 63610 of 2014 or in 3751 of 2019. There's a tendency to quote passages of statements in either of the dockets, but until now, out of this main docket, 63610 of 2014, and invite Brigadier Gwininda to comment on what those witnesses are saying. We submit, my lord, that that is improper. You cannot use, as we've objected yesterday when Mr. Ramusipili was quoting passages from some statements and eliciting the comments of Brigadier Gwininda. You cannot use inadmissible evidence in cross-examination. The only way, my lord, to use such statements is if the defense signal their intention to call those witnesses. But unless they do that, my lord, that remains hearsay evidence. And in this regard, we just want to briefly refer to the Handbook of Detroit Criminal Procedure under cross-examination on page 22 to 54, when it deals with cross-examination and re-examination of witnesses. He writes the following regarding the use of inadmissible evidence, and he says, cross-examination based on inadmissible evidence is not permitted. And he then lists the categories of such inadmissible evidence, and amongst those categories he refers to an unproven document which the witness also cannot prove. And he quotes then the case of Howard versus Decker, Vetcop and Agencies, and Forwest Estate Pty Ltd and Sousa, 1971, volume 3, essay 937T at 948E to H. We had a look at that case. It's an old case, 1971 case, and it's the decision of the then Transvaal Provincial Division. It was a civil case, but the principles are still equally applicable. And in the heading, it says, where the party against whom a private document, in this case a private document, was applicable, but the principles are equally applicable to a criminal case. Where the party against whom a private document, in this case a deed of sale, not complying with certain requirements, is sought to be relied on, has neither been admitted nor its authenticity proven, nor that the contents thereof are correct. Its contents cannot be used either as evidence or for the purpose of cross-examination. And proving the authenticity thereof, my lord, entails calling the deponent of that document to identify it. And in this instance, paragraph G, even though it was a private document, the court referred to in paragraph G, and we quote, the law in relation to the proof of private document is that the document must be identified by a witness who is either, one, the writer or signatory thereof, or secondly, the attesting witness, or thirdly, the person in whose lawful custody the document is, fourthly, the person who found it in the possession of the opposing party, and fifthly, a handwriting expert, unless the document is one which proves itself, that is either produced under a discovery order or may be judicially noticed by the court, or is one which may be handed in from the bar, or is produced under a subpoena, duces tecum, or is an affidavit in interlocutory proceedings, or is admitted by the opposing party. So in other words, my lord, the rules of admissibility of a document must first be satisfied before a document can be used in cross-examination. And this applies to all the statements in this matter, as well as the statements that were made pursuant to an investigation in First Lawrence Case 3751 of 2019. We don't want to disturb the flow of the proceedings by standing up and objecting every time. Hence, my lord, we just felt that we just need to bring this to the attention of my colleagues. Thank you.
The prescription, which is of a blanket nature, my lord, that the state seeks to impose on the defense with regard to the usage of certain statements, tends to be unlawful, and from where I'm standing, it's a bit rational, because it does not take into account the provisions of the Law of Evidence Amendment Act number 45 of 1988, which amongst others stipulates that information that is contained in a document or information that is contained in a statement may be admitted on a provisional basis, where the person who seeks to use that information undertakes to call the person whose property value the content of such statement lies. So the person who wants to use that statement can simply make an application to court and say, my lord, may I please be granted the leave to use the content of the statement, because later on then I will call the person upon the credibility, upon whose credibility the content of this document lies. There's nothing wrong with that, my lord. That is just point number one. Point number two, my lord, is the state makes a disclosure. Upon investigation, or let me actually start it here. The state receives a complaint that is investigated by police. The police go out and take statements from certain witnesses. Then the matter gets brought to court, and there's a trial such as this one. And the state makes a disclosure. In the process, circumstances had arisen in these courts, and in certain circumstances may also arise. I've also done this as well. Then you go to the list of state witnesses. Amongst the list of state witnesses is a particular Mr. X, maybe he's witness number 5. And then they call the first witness. The state calls his first witness. And then the process of cross-examining that witness, who's witness number 1. And then you refer to the statement of witness number 5, who's also mentioned in the list of state witnesses. For instance, you come and say, Mr. Witness of Brigadier Keninda, the state is going to call Mr. X, who's witness number 5, who's going to say, amongst others, this and 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 this. I'm not even so sure, my lord, whether that is unlawful, because the person that has been referred to, who the defense believes that later on will be called by the state, is amongst the list of state witnesses. So there's perfectly nothing wrong with that, my lord. Unless if the state from the beginning indicates that these are the specific names of witnesses that we are going to utilize in this trial, the rest we will not be utilizing. It is therefore upon those bases then we can approach the court and say, on the basis of the fact that the state is saying that they will not be utilizing this witness, may I then be granted leave to provisionally use the statement, because most probably this information is very important for the defense of the accused person. I may call these witnesses in our defense, and then the court provisionally then allows the usage or the content, the usage of the content of such a statement, my lord. But a blanket prescription that such documents cannot be used, my lord, I think it's unlawful and it has to be rational. What should actually happen is it should be a case-by-case determination, my lord. It should not be a blanket amnesty. I therefore do not align myself with the suggestion or with the application by my. I don't know whether it was an application, but I heard him saying that he was sounding a word of advice. I don't align myself with that advice, my lord. I may say from the bar that I'm not inclined to accept that advice. Thank you, my lord.
Okay. Yes.
I was called by my client to indicate that, my lord, the application or submissions by my learned colleague, my lord, are one-sided.
A what?
Are one-sided because, my lord, he tells me that Brigadier Gininda has referred to the statement of Absalom Zungu, which he says links accused number 1 and 2. Yet that Absalom Zungu, the state did not call, and they led evidence to that effect. The evidence of Magaleni, who's the deceased, who describes suspect B, which the state alleges is accused number 2. Also, that person was never called. We have not been furnished with the death certificate of that person. So what he essentially says is that the state may be making this application, but what is good for the gander is the warning that he sounds to us, he must also sound it to himself.
The use of hearsay evidence is governed by Section 3 of the Law Amendment Act 45 of 1988.
Is that true?
Sorry?
Is it true or correct to make that statement? That hearsay evidence is governed by the Evidence Act, Section 3 of Acts, the 45 of 1988.
There are various, I think there's about 7 requirements that must be met before one can.
Yeah, that's why I'm asking, is it correct to say hearsay evidence in this case? Because according to what I understood from Mr. Baloyi, those witnesses are alive. In terms of the Criminal Procedure Act, they must either be dead or missing.
Yes.
So that the court can find that in that instance, that evidence could be admissible in the interest of justice. But that's why I asked Mr. Ramsipiri yesterday, this gentleman who compiled the photographs, where is he? He's still alive. And he never answered me. Just said, oh, well, you know, I don't know. So I couldn't make a ruling then. Okay, go on.
No, I was also going to address the court on the basis that if the court is forewarned that the credibility of that evidence upon whose property value relies is going to be called, then that evidence may be provisionally admitted pending the calling of that witness. And in the event that witness is not called later, then that piece of evidence may be removed from the record.
Fine.
That's how I understood it. Yeah. So if the court in any proceeding, for instance in this case, is warned that the counsel is going to use an affidavit and this person is going to be called, then the witness may be cross-examined on the basis of the content of that affidavit. if the court is forewarned. Then failure of the counsel in calling that witness that was referred to earlier, then that evidence is scrapped from the record.
Fine.
That's how I understand the whole procedure.
Yesterday, when we adjourned, the court granted us the indulgence to discuss with the state regarding the status of the content of the docket 375. My Lord, we did discuss the status of that docket, and the state indicated to us that since it was discovered by the state to us and we are in possession of that information, it can be used by the defense. Secondly, my Lord, it is the duty of each and every counsel who is intending to lead evidence on a particular statement, if the author or the deponent of that statement is no longer alive, to inform the court and bring the necessary application in order to be able to use such statement when cross-examining, especially this witness who is the investigating officer in this court. As a result, my Lord, my submission is that since we have been given that permission to proceed, as the time when comes when the counsel intends to lead evidence on a certain particular statement, each counsel knows the procedure, my Lord. That's my submission.